Any mention?
Yes.
Just to mention this.
Yes.
My Lord,
2 million. 2 million. Yes.
my Lord, there's one urgent matter,
Yes.
and I pray, my Lord, to be listed tomorrow, my Lord.
What's the urgent
This
matter
is,
about?
this is a notice passed by the CM of Maharam, my Lord, saying that there will be a referendum against the military, that is against me, my Lord. In the first place, there is no provisions in the law, in the Act, for holding a referendum. Secondly, my Lord, this referendum, even though there was no provision, it was held 2 months back, somewhere 2 months back. And when they came to see the villagers, the villagers still have a support, trust
On you.
on me. Then they just abruptly stopped and they went away. Now they've issued another notice, my Lord. And that there's, my Lord, if this is not stayed, my Lord,
But then if they only your support, then why should you fear having referendum?
my Lord, because there is so much of, in the first place, my Lord,
Referendum means it will be removed.
my Lord, because
What have you done?
My executive committee also, my Lord, was formed and he has approved. Now he's questioning my executive
village?
committee. It's Nong, I forgot, Nongdown something, Nongdalang, Nongdown, something like that, my Lord. It's under.
How is the referendum? Referendum is a democratic process.
I'm sorry, my Lord.
It's a democratic process. It's like floor test in assembly.
My Lord, but there's no the only fear is, my Lord, because the villagers are not taking it kindly, my Lord.
Okay,
That's the only thing, my Lord. I'm
tomorrow?
deeply obliged. Tomorrow, my Lord, because Saturday is a referendum. Obliged, my Lord.
Your Lordship, I beg to mention item number 13.
1-3.
Yes, Your Lordship. Your Lordship, in this matter, on the last occasion, we had submitted that a review is being conducted with regard to the rules, Your Lordship. Now, yes, Your Lordship. Your Lordship, now a special committee has been constituted.
The matter is regarding what?
It's regarding the officers in the education department.
The
Promotion and upgradation, Your Lordship.
Full divisional
Yes, after?
officers.
Your Lordship, here,
Lordship, on the last occasion they had, because they said that they'll take steps to review the rules.
They're taking steps now.
yes, Your
months.
Lordship, a committee has been constituted to
3
look
months
into
was
the
given.
rules.
3 months were already expired, Lordship.
When
months
that?
was given,
3
Your
months.
Lordship.
Before this court.
Lordship, they had brought the minutes before this court saying that we'll take 3 months time.
Take 1 month more time. Let's see.
Your Lordship, if we can get a minimum of 2 months, Your Lordship, because they're
Why?
amending the rules, Your Lordship, so the same will
Okay,
have
2
to
months.
be placed.
If it works, your benefit well and good.
We're not quite sure.
Doesn't matter. You'll remain your yes.
Obliged, Your Lordship.
On the request of the respondents, as it is stated that the matters under review, this is matter after 2 months to await any outcome.
Positively, Lord, within 2
2
months.
months, yes.
Obliged, Your Lordship. Your Lordship, I have a similar prayer for item 25.
Item?
25, Your Lordship. Conducting counsels on sanctioned leave.
Who's conducting counsel?
Mr. Essen.
Fernandez, Mara, you have any objection? You have objection.
No objection, Lordship.
You nodded just now?
No.
Okay, 2 weeks, yes.
Obliged, Your Lordship.
Your Lordship, I beg to mention item number 24, Your Lordship.
Other side?
Your Lordship, here the petitioners had filed a representation before the department. Your Lordship, the representation has been replied to, Your Lordship. I apologize, Your Lordship, the copy is not so clear.
So you're in your favor.
Yes.
So what do you want to do?
Let it come after 2 weeks, Your Lordship.
2 weeks?
No, I mean 1 week, Your Lordship.
Your
I'll
Lordship,
just
the
inform my
matter
client.
can be
Your Lordship.
disposed because they are in the
Let him take
process of...
instructions.
Yes.
He needs material instructions also.
Yes, Your Lordship.
Yes.
After a week, Your Lordship.
Yes, MSZE Nongkanri informs the court that the representation filed by the petitions has since been disposed of by an order dated 11 July 2024. A copy whereof has been produced for the court today. Mr. Pinho, next paragraph. The president please give allowed 1 week's time to obtain specific instructions. Yes,
All right.
placed accordingly.
Obliged, Your Lordship.
Copy of the orders kept and made part of the record, yes.
Obliged, Your Lordship.
Yes.
Lordship, I beg to mention item number 19 and 20, only for a week.
No objection, Your Lordship.
1 week is
I'll oblige.
under prayer of the counsel for the petitioner. Yes.
May it please, Your Lordship. Lordship, I beg to mention item number 11. 11 and 12 are connected matters, Lordship.
11.
11 and 12 are connected.
Same one. That 11 is that contempt.
Yes, Lordship. Contempt.
After 1 week, Mr.
My lord.
Dr. Mozikal will be back.
2 weeks, Lordship.
Okay, 2 weeks. Yes.
Lordship, I have a similar prayer for item number 14. 14 to 18 are connected.
14 to
18 are connected, Lordship.
yes. Right.
Highly obliged.
May I please, Lordship? I beg to mention item number 22.
20.
22.
Where's Mr. Sheikh?
He is on sanction leave, Lordship.
He was here yesterday, correct? Yes. Yes, after any urgency?
No, Lordship.
After 3 weeks, yes.
Similar prayer for item number 26, Lordship.
20?
26.
Any urgency?
No, Lordship.
56. No urgency. 3 weeks, yes.
Much obliged.
Yes.
Lordship, I beg to mention item number 23, Lordship, of the main list, Lordship.
Why?
Lordship, Senior has some difficulty, Lordship. I'm praying for next week, Lordship.
You're appearing for?
CM.
Where's the counsel for the... Who you are arguing the matter today?
Yes, Your Lordship.
You're arguing.
Ma'am will argue, Your Lordship. She's on the way.
Lordship, I'm praying, Lordship, if this can be taken up next week, Lordship.
This matter court also dispose of. Orders have to fall. Where's Dr. Mozika is not here also. Where's Mr. Shulai?
He's on legs, Your Lordship. He's here.
Okay, after 1 week.
Lordship.
Yes. In the prayer of competition.
Mention item 29, my lord. Praying for 1 week time.
This matter, why are you taking time again?
Next week, my lord. Today, some difficulties there, my lord.
You're pressing for hearing.
My lord, my lord. Next week, my lord.
Beforehand, you should inform beforehand.
You're appearing for?
Not for the private
Private
respondent.
When who? Where's Mr. Sen? He's not here. When?
Next week, any date, my lord.
After 1 week, yes.
Obliged, Lordship.
Supplementary list, item number 1.
May it please, Lordship.
Yes, definitely.
Lordship, we have filed this revision petition, my lord, for expeditious disposal of the 2 missed cases, my lord. 2 missed cases, my lord.
It's come the first time this time, today?
No, my lord, last week it had come. It's first time, my lord, today.
Okay.
Then we had...
What happened? Yes. Tell me. Tell the court, rather.
Lordship.
Yes.
Here, my lord, sometime in the year 2015, my lord, we had filed 1 missed case, my lord. Under section...
Missed case?
Yes, Lordship. Under
15?
section... 51, my lord.
No, in the year?
15, my lord. 15.
15, you filed a missed case?
Yes, my lord. That
For?
missed case, my lord, for my lord, restraining the opposite parties, my lord, for interfering in the peaceful possession and occupation of my suit premises, my lord. So there was frequent interference, my lord. So, my lord, I had filed an application. So subsequently, my lord, missed cases were filed, and my lord, under section 40 also was filed. So till date, my lord, this application is
You
yet
mean
to be
to say
disposed
that
of.
your missed case was filed in 2015, till date not been disposed of?
No, my lord.
How is that possible? Where is CIS? It's here?
Yes, my lord.
Even next year?
Yes, my lord.
The matter has been listed consistently.
Yes, my lord.
And from 15 till now, 9 years, how a miscase not
Lordship, what has happened is there was some inspection also carried out, and another miscase was filed. For that reason, my lord.
And the main suit is at what stage?
Main suit, my lord, is at the stage of evidence, my lord. Plaintiff's evidence.
And suit was filed on?
2014, my lord.
2014 suit was filed. Miscase for 2015.
Lordship.
Now for hearing on the misapplication is pending till now.
Lordship.
That's strange. Yes. We'll issue notice. Who's the other side?
Lordship.
Who's the counsel appearing in the?
I'm for respondent number 4, Lordship.
Actually, state doesn't have any role, my lord.
Yes. No. You're the plaintiff or you're
yes, I'm for the defendant, my lord.
The defendant. Who is the lawyer plaintiff there?
Plaintiff, Madam PDB Barua, my lord.
Mr.
Madam PDB Barua, senior counsel.
You serve notice, they won't accept.
My lord, may kindly permit us to take Dasti service also, my lord. We'll take steps.
How was the matter 2015? Only that's only prayer.
Yes, my lord. Subsequently, my lord, we had filed one more application challenging the mandate of the suit, my lord. Both applications, my lord, we are praying for expeditious disposal.
Whatever it is,
lordship.
Your miscase dismissed or allowed that petition should be taken now. Heard Mr. Panthi, as a petitioner, issue notice. The respondent number 4 is represented by Mr. Khan. No further notice required on this respondent. Petitioner to take steps for service notice upon the respondent 1, 2, 3 by receipt 80 within 3 days. On the prayer, Mr. Panthi, service by Dusty service also permitted just after 2 weeks.
Deep relationship.
I mean, quite strange. 15.
Daily list item number 1.
I have a similar prayer, Lordship. I'm praying if this matter can be taken for next week, Lordship. I'm praying. This matter is fixed for admission hearing, Lordship. Learned Senior has some difficulty, Lordship, today.
Mr. Chanda prays that matter came after 1 week. Why?
Lordship.
What's the reason you said?
Lordship, some personal difficulty on behalf of Learned Senior, Lordship, Mr. P.
Because of personal difficulty of the arguing counsel, arguing counsel, it's after 1 week.
Item number 2.
Who's appearing for 124?
I'm appearing for respondent number 5 and 6, Your Lordship.
You file affidavit 124?
124.
Where's Mr. Kiwi?
No, they're not yet filed.
For time, Your Lordship.
Do you see in the last order?
Your Lordship, Mr. Kipi charges in this matter, Your Lordship.
Have you seen the last order?
Last order is not there. Last chance is given. Received the copy. They've already received the copy.
What's the matter about?
Regarding teacher matter, Lordship.
Regarding?
Lordship, here they have challenged the imping order dated 24 January 2017 and January 2017.
17?
Your Lordship, and 15 February 2017, where the respondent number 4 has cancelled their approval order for assistant teacher of social studies.
Okay. Where's Mr. Keyboard, Saji?
Your Lordship, I've not seen him.
We'll have to after some time.
Item number 3.
Yes,
May I please, Your Lordship. Your Lordship, we have filed our rejoinder. The matter may come up for hearing, Your Lordship.
Not received copy.
Who's appearing for? For the petitioner. Yes, Mr. You received copy rejoinder?
Yes, Your Lordship,
Submitted rejoinder has since been filed, and as such, the pleadings are complete. Stopless for hearing on so and so.
Highly obliged.
Obliged, Lordship. Item number 4.
Got promotion?
The proposal from the department has gone to the EC. And
when are you retiring?
2026.
We still got 2 years if we get promoted.
So it's this year, this month it is almost 1 year, Lordship.
I've got an internal
Memo.
just issued to the court. Second last paragraph, the name of the.
At present, Sri Besarani is the senior most per record Ministry of Himself.
On the last 4 paragraph, we have. This is there going to be a policy decision of the EC on the proposal of the Chief Forest Officer and his department. That's why it took time, Your Lordship.
I like this last paragraph.
Yes, Your Lordship.
Further, in order to be able to sustain a payment of monthly salaries to all officers and feel it's necessary to maintain the minimum strength with maximum capabilities. Very good order. Even JHDC should adopt this. Minimum strength with maximum capabilities. Not maximum strength with minimum capabilities. What to do? This is dated 8th of July 24.
We'll keep this pending, Your Lordship, this matter. It'll come after a week or 2 weeks.
Yes, in this matter regarding the...
Lordship, a copy of this maybe supplied to me.
It's internal, Your Lordship.
Okay, then we won't record it also. Listed after 2 weeks.
Yes.
Hopefully by next date, the order should be valid, should be complied with. Given promotion, if you already made a policy decision.
So 1 year.
Why make
almost 1 year, Lordship.
Why make him wait?
6 weeks time was given by Your Lordship.
Item number 5.
Your Lordship, the state
Yes.
has. Your Lordship, the state has filed the affidavit.
Yes, it's already recorded last time.
Yes. So
you filed
can
a rejoinder.
uh,
You
we
already took
haven't-
time also to file a rejoinder
We
on
haven't
16/7.
filed the rejoinder yet.
You have not filed. You don't want to file.
If
You want to
required, we
file.
will file. But
They allow for rejoinder. Just thereafter.
Your Lordship, my prayer is that kindly let this matter be posted for hearing.
You don't want to file rejoinder.
I will.
You file rejoinder first.
Okay.
Yes.
Item number 6.
Lordship, affidavit on behalf of the respondent will be filed in the course of the day.
MSA Prasan submits that after on behalf of want to file the course of the day. List after you want to file rejoinder. You don't know. List after 2 weeks for rejoinder if any.
Item 6 and 7, Lordship. 6 and
Lordship,
7.
in
Item 6 and 7, Lordship.
Item 6 and 7 are connected, but in item 7, Your Lordship, we filed one missed case regarding the correction of name of the petitioner with white order dated 7/5/2024 of this month. The order was passed to correct the name, but then the spelling in the order was wrong. So we filed a missed case to correct the actual and correct name.
Spelling in the
Order dated 27/05.
of this court.
Yes, Your Lordship.
Instead of reading as Sri Ram Saini, the same habitation Ram.
His actual name is SHRI, Shri Ram Saini, not SHREE.
SHRI.
Yes, Your Lordship.
His name is SHRI.
Yes, Your Lordship.
That means he writes him Shri Shri.
Yes, Your Lordship.
His name is Shri Ram.
Yes, Your Lordship. We
But-
attached documents as PAN card, Aadhaar card in the miscast.
This leads to a lot of confusion.
Yes,
Shri
Your
Ram
Lordship.
Saini is his name. So what do you want by this? Correct his name again.
Yes, Your Lordship.
Yes. Take down. Earning a Miskay 93 in WBC number 118. Stop. By this application, the writ petitioner seeking to correct a bona fide mistake of the counsel for the petitioner, wherein the name should, instead of reading as SHRI, Shri Ram RAM Saini, the name was entered as Ram Saini. Further, this court it appears by order date 27/5/2024. Instead of recording the name as SHRI, a lot of confusion.
Yes.
Ram Saini, the same as shown SHREE. Ram Saini. The petitioner, the council petitioner appears that he allowed to enter the correct name in the cause title before the registry. Prayers allowed. Yes. Necessary corrections to be done in the course of the day. We should change his name.
Yes.
It would happen to one senior lawyer in this court also. When the time came for consideration of his senior advocateship, by the time under Gauhati High Court, and so his name is, you might know, Shri is in front. So when it came, so who's this? We don't know this name. But let me the second part.
It will be double Shri.
Yes. Shri is no problem.
What's your
Highly obliged.
Item number 8.
Your Lordship, I am entering appearance on behalf of respondent number 5, Your Lordship. I'll be filing the power in the course of the day.
What about 4 and 6? Yes.
I have taken step on respondent 4 to 6, Your Lordship.
No, 5, what about 4 to 6? 4 is whom?
Scheme of Miriam.
4 is?
4 is the scheme of Miriam.
4 is the scheme of Mriau. And 6 is Sardar Onginyong. So, Mr. B. Kriam has entered appearance on behalf of the respondent number 5. Stop offer's note indicates that AD card in respect of 4 and 6 is yet to be received. You want to file affidavit?
Yes, Lordship.
Mr. B. Kriam prays from the law. How much time?
2 weeks.
2 weeks time to file affidavit. This up to 2 weeks for affidavit of for appearance of and for service report on 4 and 6.
Obliged.
Supplementary list. Hearing. Item number 2.
Wait, please, Your Lordships.
Well, let's just come to the point, Mr. Sen.
Yes, my Lord, I am coming. I'll just come to the point.
Regarding that
What
duplication-
is my case, Lordship? Okay, can you just refer to the scheme of the agreement, Act. That is the, my Lord, Employees Provident Funds and Miscellaneous Provision Act 1952. Now, my Lord, it starts from Section 7A, my Lord, the relevant, which are relevant for this case. 7A. Now, my Lord, 7A speaks about, my Lord, determination of monies dues from the employers. Now, this obviously by the contribution to be made by the employers also included, my Lord. Now, this speaks about, my Lord, how it is to be determined, an inquiry has to be made, and after giving opportunity, etc., my Lord. Now, Your Lordship, 7B speaks about review. Suppose an assessment was made, my Lord, some party is aggrieved, certain points has been, certain facts has been missed out, then a review can be filed. Now, my Lord, what is most important here, Your Lordship?
We're using 7E, okay.
7A. 7A, determination of the
Yes,
contribution.
money due.
My Lord, how it is to be done by inquiry. 7B speaks about
Review
of
orders.
the order passed under 7A. Suppose, my Lord, certain amounts, my Lord, certain facts were not taken, Lordship. Now, I will take my Lord to 7C.
Yes.
7C is very important, Your Lordships. This speaks about an escape amount. I'll just read it again, my Lord. 7C, determination of escaped amount.
Yes.
Where an order determining the amount due from an employer under Section 7A or Section 7B has been passed, and if the officer who passed the order A has reason to believe that by reason of omission or failure on part of the employer to make any document or report available or to disclose fully and truly all material facts necessary for determining the determining the correct amount due from the employer, any amount so due from such employer for any period has escaped his notice. Now, this is one thing, my lord, that the employer has not cooperated, concealed certain documents. I'm just instance, my lord. Resulted into, my lord, proper determination was not done, certain amount escaped. B, has in consequence of information in his possession reason to believe that any amount to be determined under 7A or section 7V has escaped from his determination for any period, notwithstanding there has been no omission or failure mentioned in clause A on part of the. Now, this is another ground. Now, this is a ground not due to, my lord, concealment, but due to the fact that the information, my lord, the officer himself has missed out. This can also be a reason, ground, my lord.
Yes.
Then what he can do? He may, within a period of 5 years, Lordship will take note, from the date of communication of the order passed under section 7A or 7B, reopen the case and pass appropriate order redetermining the amount due from the employer in accordance with the provision of this act, provided that no order redetermining the amount due from the employer shall be passed under the section unless the employer is given a note. Then there has to be, my lord will take note, 5 years. This is that process, speaking about the contributions. Any amount escaped either due to the non-cooperation by the employer or due to some, my lord, oversight of the assessing officer. Then within 5 years, my lord, that's very important. Now, my lord, in case, my lord, let's refer to them as escape amount. No? In case of escape amount, my lord, the Act has provided categorically an enabling provision. This is the enabling provision, that if amount escape within 5 years, you can reopen it. Now, here in this case, my lord, what happened? For a relevant period, my lord, what happened? The contribution was determined, the interest was determined, damage was determined, all were determined. Then, my lord, I was aggrieved. I came before this honorable court. This honorable court intervened and reduced the amount to 25%. And pursuant to this court's order, my lord, I have annexed all the documents. I have made final payment. That was accepted. Now, my lord, almost after, my lord, that happened, my lord, sometime in 2008, final payment.
When the final payment was made?
Yes.
After reopening?
Yes.
After assessment?
After assessment. That was after assessment. There was no reopening.
Yes.
So, finally paid. Now, here, my lord, only 2021 they have issued again a notice. Now, they are talking about interest and damages, including the period for which I have already paid at the intervention of this court. Here my humble submission, my lord, on law, for reopening a case, there has to be an enabling provision.
Yes.
Now, regarding, my lord, the fund, principal fund, there is an enabling provision 7C, and they have stipulated a time limit of 5 years. Now, if your lordship look into the other part, my lord, there is no other enabling provision in this act, my lord, which empowered the assessing officer to reopen the case of interest and damages. On this it goes. Where is the enabling provision? There has to be enabling provisions. Now, my lord, I will take, my lords, the period for which the assessments were made. I'm just refreshing. I think I have.
Yes, of course.
No, payment made, my lord, pursuant to the High Court's order. No, for that period, that, my lord, letter I have annexed, my lord, Annexion 9, page 69. 3rd September 2008.
Yes.
Lordship. Sir, in compliance with the order passed by this honorable court in WPC number such and such, dated such and such, we are hereby paying the full amount of 1,83,000 such and such, and interest amounting to rupees 344, being the final settlement of the amount due to you. The detail under these headings it has been deposited are enclosed herewith. So, my lord, whatever that, my lord, I can take your lordship what were the calculation they made, which was before this honorable court, your lordship. That is at Annexure 6. Annexure 6, my lord, page 62, which was the subject matter of earlier writ petition. My lord has got it. That is dated, my lord, 29/4/2005. Lordship will kindly come to page 63, my lord, the table. Now, what are the charges? 7Q, interest. 14B, interest. Now, for the period, my lord, 388 to 6/2001. So they have not only, my lord, these includes, my lord, 7Q and 14B.
Yes.
Madam. So, my lord, interest and damage they had already assessed, my lord, and this was the subject matter of the earlier writ petition. This has been finally settled, amount has been paid.
Yes.
Now, in the absence of enabling provision, my lord, how this officer could have reopened it?
Under
This is
14B.
all relating to 7Q 14B. Only 7Q 14B, my lord, not the principal. Now, my lord, next page is the order of the this honorable court. Now, there is no dispute in the bar, my lord, in pursuant to this, whatever has been determined by this court, I have not paid, I have paid. Now, my lord, they have issued a fresh one, your lordship, at Annexure 10. That is also, my lord, payment, final payment was made 2008. This came in, my lord, 15/12/21, after 13 years.
With orders dated 12/8.
After 13 years, your lordship.
After 13 years.
After 13 years, my lord, I
Was
don't
the
could not
notice-
understand. Without any, first thing, without enabling provision, my lord, they could not have reopened at all. There has to be an enabling provision, like 7C. Now, for the period, my lord, if your lordship come into for which period they have mentioned, my lord, in the just immediate below the table at page 70.
Page?
The page 70, Annexure 10. Just below the table, my lord. Now, first table. Now, the scrutiny of the records maintained by this office for remittances made during the period from 1/4/96 to 31/3/2014. That was subsequently corrected as, my lord, 10/97 to 4/2007. I will show your lordship. Shows that there are certain payments which were made after respective due dates, and the total amount by way of penalty and amount of interest on such belated payments are this. Now they have recalculated for including the same period again. So my grievance is, my lord, where is the provision, enabling provision? And this is all about, my lord, interest and damage. There is no enabling provision for reopening the interest and damage, except, my lord, the principal amount. But that has to be done within 5 years.
12.
Yes. That has to be done within 5 years. Now, your lordship, I will take my lord to Annexure 11. Now, they have corrected the period in this case. Lordship will come into the bottom period of inquiry 10/97 to 4/2007.
Annexure 11.
Page 75.
Yes. 17/6/22.
Lordship.
They have corrected to period inquiry 10/97 to 4/2007.
This is the period. Now,
Nearly
these
10
include the
years.
period for which it was finally settled. And that was, lordship will kindly take note, specifically, my lord, damage and interest. No, where is the, there has to be an enabling provision that you can reopen, even if it is escaped. I am not considering as any amount escaped. Even if it is escaped, like 7C principle, there has to be an enabling provision. When the legislature, my lord, have not incorporated such a provision, you do not have the power. How you exercise this power? And there too after 13 years. Now, my lord, ultimately come your lordships. The final order, my lord, which is under challenge at Annexure 15. Lordship, relevant part, lordship, my lord, will get at page 86. Page 86, my lord. Last subpara. For the reasons stated above, I such and such Regional Provident Fund Officer, Region Shillong, in exercise of the power conferred upon me by Section 14B, 14B of the Act, levy damages amounting to rupees such and such only for the period. The account-wise breakup is this, my lord. Now here your lordship will do 14B and 7Q, interest and damages.
Yeah.
And then ultimately, my lord, the last paragraph they say, my lord, how they will recover it. Now, my whole case is, my lord, on this enabling provision. In the absence of an enabling provision, you cannot reopen, except in the case of the principal amount. Here is not the case of the principal amount. And even in the case of principal amount, there is a period of limitations, 5 years. So, my lord, it goes on this. Cannot be sustained. And the other thing will be, perhaps, your lordship, that period was up to 2001, which was finally settled. What about the other period? Now, regarding the other period, my lord, the question is, could they have reopened it? That's the deal. I cannot segregate it. This is by a combined order. It cannot be segregated. I cannot segregate it, my lord, because up to 2001, this was finally settled at the intervention of this court, and I made the payment. So my humble submission, my lord, this is partially illegal, my lord. Where is their part? Let them explain, my lord, without going into other things, where is the enabling provision? If there is the enabling provision, yes. If they are within limitation, yes. Otherwise, no, my lord, they cannot. So my humble submission, it needs to be interfered, my lord.
Yeah, they say 14B there's no limitation, correct? That's your, there'll be.
Where is the enabling provision to reopen?
Yes.
Lordship, 14B is under appeal, Lordship. The appellate court has the power to adjudicate the matter if order is passed under 14B and 7Q. Lordship, now more so, Lordship, what my learned senior has already submitted, this is their second default, Lordship.
Second?
Second default.
Second default in which manner?
2001, if we take it consideration that the 2001, my notice is, Lordship, my notice date is 2000 up to 2007, Lordship, for 2007. That means, Lordship, they are defaulting after 2001, they are continuing defaulting. If the court has adjudicated also, Lordship, they have not taken it as a, that yes, this matter is settled, now, from now onwards we will be paying on time. No, Lordship.
So you mean after the final settlement, they continued delayed payments?
They continued with the delayed payments, Lordship. It is not a case that once I got a penalty, I got a punishment for what I have done, still I am repeating my offence. Is this an excuse, Lordship?
But then why haven't you clarified that period?
Lordship, the clarification of that period we have already clarified,
Where's
Lordship.
that?
Lordship.
Okay, fine, up to the period where it was adjudicated by the court, the Provident Fund Commissioner will not raise any other issue. But with subsequent periods which are not covered by the judgment of the court, where the amount was fixed. Now, if they continue delayed payments, then in the hearing, is that reflected in the impugn order?
Lordship, the orders which are passed, the order is passed based on our summon, Lordship, and based on the calculation which we have given, Lordship. In the calculation, we have not taken that into account the months which were those months. Suppose 97, Lordship. For the 97, Lordship, we have not taken into consideration November 97. So in this notice, I have taken into consideration November 97, Lordship. It is not, in that notice, November 97 was not taken into consideration.
You're saying they're not escape amounts?
It is not with escape amount. Escape amount is particularly with 7A. My notice is not under 7A, Lordship. My notice is under 14B, 7Q.
So in 14B, 7Q, there's no limitation?
There is no limitation, Lordship. I have not gone in the first phase, my notice, I have to go under provision, Lordship. I have to first send, while sending notice, I have to take into consideration, yes, whether you are coming under 7A, whether you are coming under 14B or 7Q. My notice, I have not gone in 7A.
Okay. You say that action is not under 7A. Okay.
It is not with escaped amount. I have not gone under 7A.
Yes. Now it's only for delayed payment.
Only for delayed payment.
where you are charged when delay payment, when is due, when is paid.
And which is an appealable, my order is under appeal, under 7I, it is an appealable. There is no
this
appeal.
I have already, your lordship said, this, my lord, entire case depends on the judgment passed by this honorable court.
No, then you file appeal if that is the case. If they maintain that is not a notice, not escaped amount, the amount is simply put, from what I can understand, maybe I'm wrong. But the thing is that this proceeding is not under 7A at all for escape amounts. This proceeding is for repeated delayed payments after the adjudication by this court. So some fixed amount was given, you paid, and then after that there are delayed payments with regard to the payment of the contributions. And so 14B, there's no limitation.
No, what I am saying, I think unable to place my case. I never said it is under 7A. I never say.
You said it's escape amounts, and so there's no enabling provision for them to reopen the case. It's not a question of reopening them. If her argument is correct, that means she says that it is a totally fresh proceeding directed, on the delayed payments made after 2001.
No, what I mean, lordship, bear with me.
Yes.
What I please, the scheme of the act. Now, what is the scheme of act? There is a 7A. I never say this is a notice under 7A. Now, 7A amount is to be determined, the principle has to be determined, inquiry has to be made, they have the civil power, etc., etc. Now, my lord, an order is passed. Now, 7B. Now, 7B speaks about review. Suppose there is some kind of error and all, either party, my lord, they can seek a review. 7C speaks about, my lord, escape amount. Obviously, escape amount in respect of the principal contributions. That means, my lord, what the act indicates, my lord, if there is
it contemplates three situations.
A situation, that is there. And one thing, my lord, which is very important, this act contemplates one thing very clearly, that for a period determination already made, but subsequently if it is found that there is some escape amount with regard to the principal, my lord, then, my lord, 7C is an enabling provision, gives the power to the assessing officer that you can reopen. But you can reopen
for 5 years.
5 years. Now, these I am citing as an example, my lord. If there is an escape amount, whether, my lord, principal, then there it has been provided, provision has been provided, enabling the officer to reopen within 5 years.
There is also an appeal, lordship. If that is the case, then there is also an appeal.
Escaped amount is different from delayed payment.
No, I am coming, my lord.
Escape amount is depending on the assessment, which when any contributions have
I have not finished, my lord. This is one principle. Yes. This is I am citing as an example.
Yes.
Now your lordship will come to interest 7Q 14B. Now 7Q 14B also, my lord, these are to be determined. These are to be determined on the basis of, my lord, delay made on the payment of the principal.
Yes.
Now those were finally done. That judgment of this honorable court dealt with, my lord, for that period 7Q 14B. There is no dispute in the word. 7Q 14B for that period assessment was done.
Up to 2007.
Up to, my lord, that case of course I do up to 2001.
Okay. Yes.
2001. So at the intervention of this court, my lord, the amount was reduced to 25%. Again, I am repeating, my lord, at the cost of repetition, I am saying 7Q and 14B. Right. Finally assessed. Now, my lord, the question is this: assessment finally done. Now, can they reopen, my lord? Not principal again, I am saying. Can they reopen the assessment of interest and the damages for that period done? Because for that, similar provision is required to be there, as has been provided in 7C.
You want to read 7C into this action?
No, I'm not 7C.
Of course.
Otherwise, 7C, why 7C is required?
No, you're saying that if the any provision is there for escape amount, there should be a similar provision.
Exactly. There has to, I'm not saying only this. There has to be, to exercise this kind of power, to reopen it, there has to be an enabling provision. Otherwise, my lord, for principle, they would not have provided 7C. They would have said, my lord, it would have been silent. Anytime they could have opened. So in 7Q and 14B, your lordship, there has to be enabling provisions. In the absence of enabling provision,
I think he'll have to go under 7I.
7I, lordship.
7I.
Because entire whatever he is saying, lordship, it's all under appeal, lordship. There is no other option to go for.
You see 7I?
Oh, appeal, your lordship. Appeal, my lord, one thing I'm saying, my lord, the This involves, my lord, judgment of this court. Now, my lord, it's not
Judgment
clear,
of
my
courts is water under the bridge. If we see the amounts only for 2001, the adjudication was only 2001.
Lordship.
Then it's up to them to see that
No,
whether
2001. But my whole grievance here, your lordship, whole grievance is up to that 2001. How can you do which has been finally satisfied? Finally satisfied.
Also included, Lordship.
Also included, they say. 2001 up to 2001, then up to, my lord, they have included that period.
The entire dispute, you can take it there.
Lordship. And another thing, your lordship will look into the provision of this act, of what it says 7I. Any person aggrieved by a notification issued under the central
Or an
government order passed 7I.
Or any authority.
By the central government or any authority under provision to
yes.
section or subsection 4 or section 1 or subsection 7B, except an order rejecting an application for review referred to in subsection 1, section 7C, 14B. 7Q is not included here.
Part is there, Lordship.
7Q is not included.
14B
So
is
my humble
applicable,
submission,
Lordship.
one thing, High Court's order is there. Second thing, my lord, 7Q is not included. So, my lord, the effective remedy, my lord, is not available. That's how I am before, my lord. And again, I am saying, my lord, there has to be enabling provisions.
See, Mr. Sen, 14B is what?
Damage.
And 7Q is what?
Interest.
Then?
Yes. It's two separate. Interest and damage are different things. Interest has to be calculated the way they have provided. No, 7Q is not included.
Interest is consequential.
Consequently, on the depend
damages
on how it
is the main thing.
On depend on the delay, my lord.
No, yes, damages is the main thing. If your damages is educated, then interest will follow accordingly.
No, my lord, what I have
damages 14B is damages. Now, what are damages? What damages are you liable to pay for a delayed payment? Now, damages will be given. Then on damages they calculate the interest for the period.
But the fact is,
damages is interest is consequential. It's like gratuity. Now, gratuity payment, whether it's your right or not, fine. How do you delay? The delay is there. You have to pay. Then interest on the delay.
This is the my lord interpretation. Lordship will look into the act provision. Provision is silent about 7Q.
See, that the thing is that you have we of course not saying that you don't have a case that doesn't require examination, but the thing is that there's only some confusion with regard to the period of which they have given. Now you say that this period is not open for reconsideration anymore.
No.
Yes, it's not considered because that because it includes matters that have been adjudicated. She says that no, it has been included, but it's actually for a period from 2001-2007. Now, who's to say?
No, not 2001-07. Lordship will look into. Lordship will come to the notice.
See, let's go to your chart. Where's the chart for date?
Lordship will come to their notice.
Let's come
what
to
the notice?
Come to 72.
Page yes, Lordship. Page 72.
Come to 72. Okay.
72.
Now, these periods, you see, these periods should be already reconciled up to 4,004, 5, 6.
Yeah, this is starting from here. It starts from 97. Same thing. 97 to 2007 only. Same thing. That is what is reflected.
2001.
97 to the last page. Your lordship will come to last page.
That's what I am saying.
2007.
Lordship, November 97. But they have paid when, Lordship? 7 to 2004. Lordship, the matter was adjudicated in 2001 also, Lordship. But they have paid after 2001, 2004.
Let's see the High Court order, 2008. So, of delayed payments,
Lordship,
they paid, 6,006 for amounts due on 15,706, they paid in 2008.
This is that page, Annex 7, page 64. This is dated, 12/8/2008.
8, Lordship.
Page 65, I'll just read hard, Lordship.
But for 97, they have paid in 2004, Lordship. And
hard,
in my
SSN, Learned Counsel for such and such. In the writ petition, the petitioner is questioning the validity of the order number such and such.
Let's see the order. The order of this court. Page
65.
Page
65.
This is the senior Mr. Sen. Yes.
In this writ petition, petitioner is questioning the validity of order number such and such, 7Q and 14B, my lord. Again note, dated 19/10/2004, issued by the Assistant Provident Fund Commissioner Shillong, and a demand notice dated 29/4/2005, issued by the same authority for payment of damage and interest under 7Q and 14B of the Employees Provident Funds and Miscellaneous Provision Act, such and such. By the impugned notice, the order total amount was sought to be realized from the petitioner for belated remittances of his contribution. There is no dispute at the bar that the penalty by way of interest and damage sought to be realized from the petitioner is to the extent of 100%. It may not be out of place to notice that the petitioner is the principal of the Loreto Convent, Shillong, and that as required by the provision of the Employees Provident Fund and Miscellaneous Provision Act 1952, which is undoubtedly applicable to the institution in question, the petitioner is required to maintain Provident Fund accounts for all its employees. In the month of February 1997, petitioner received a notice dated such and such under Section 14 of the Act from the respondent number 3, requiring her to deposit her contribution dues within 7 days. According to the petitioner, the compliance with this notice, her contribution was deposited in the APF account in the State Bank, and in the month of April 1998, she also transferred the accumulated fund in the Allahabad Bank of APF account in the State Bank, and was duly communicated to the respondent number 3 by letter dated such and such in the month of October 2002. The respondent number 3, however, initiated a proceeding against the petitioner under Section 7A of the Act to ascertain as to whether all the dues has been paid. In course of inquiry, the petitioner explained the circumstances under which the Provident Fund amount were deposited in the Allahabad Bank. Apparently dissatisfied with the explanation given by the petitioner, the respondent number 3, by order dated such and such, directed the petitioner to deposit a sum of rupees 6 lakhs such and such, being the balance due under various accounts within 15 days from the date of the receipt of the order. The petitioner duly deposited the aforesaid amount by challan dated such and such, and also intimated the same to respondent number 3 by letter dated such and such. The respondent number 3, however, issued the notice dated such and such in 7Q and 14B of the Act, imposing the interest and damages referred to earlier. The learned senior counsel for the petitioner, drawing my attention to the decision of the Apex Court in such and such, reported in AIA 2006-1767, submits that the damage imposed by the respondent number 3 upon the petitioner in terms of the aforesaid notice to the extent of 100% is highly excessive and contrary to the said decision of the Apex Court. In my judgment and order dated such and such, in a case which is somewhat similar to the facts of the case, I have reduced the damages imposed upon the Don Bosco Technical School, Shillong, from 100% to 25%. Needless to say, my aforesaid decision was passed in terms of the decision of the Apex Court. Therefore, there is no legal impediment in passing an order in the nature passed in WPC number such and such. The quantum of damage being reduced to 25% herein will be at the sum of rupees such and such by leaving the interest payable intact. For what has been stated in the foregoing, this writ petition is partly allowed the damages imposed upon the petitioner by order of such and such by the impugned notice, and the order dated 2004 and 5 shall
So this
stand.
is for what period this order covers then?
Lordship, this
You have the records of the old case?
Lordship, the
This is
notice.
there. My notice is there at page 62, Annex 6.
For the old period?
Yes.
Lordship, page number, page.
388-26-2001. Page 63, my lord. That's what I referred to.
Yes, but she's stressing that after 2001, that the lead payments being done. Correct?
Lordship,
I stated that in the
It has
affidavit.
two-part, your lordship. Now, up to 2001, how they could have included 2001? They have also included from
That
19...
that is wrong. That is wrong. No, but regarding this, have you stated in the affidavit that is post 2001?
Lordship,
Because it's
if I
already
can
reconciled.
continue, Lordship,
Whatever is right or wrongly,
2001
whatever you
also
did challenge this order, passed by this court.
Never challenged.
Lordship, no, the orders are not challenged. But Lordship, let me come. I cannot place my arguments. My senior is interfering. Let me face.
Lordship asked me to read the judgment. I have read the judgment.
No, Lordship. I am coming, Lordship. Now, Lordship, if I draw Lordship attention to from page number 5, Lordship. From page number 37 onwards, Lordship. From page number 37 onwards.
Okay.
These are all calculations, Lordship, on which, based on which I have my summons are and my orders are, Lordship. Though randomly I have taken the entire period.
Page 37 of the writ petition.
Of the writ petition. These are the calculation based on which I have passed my order. I cannot go beyond this, Lordship. Though I have covered the years, but it is from page 37 onwards.
Show what do you want to show?
Now I am showing, Lordship.
Yes, just show.
Lordship, if simultaneously, Lordship, I need to take attention, Lordship, to page number, because simultaneously.
No, see, one thing.
Page number 72 also, Lordship.
You see page 37, just come to the first one. Due date 5/4/1988.
Yes, Lordship. This is my previous notice, Lordship.
And payment was made on 17/2004.
That's why, Lordship. There is a long period of.
No, but this amount already be reconciled by the order.
Yes, Lordship.
Then
I'm saying, Lord.
Yes.
I have covered, Lordship. In this, these are the calculation based on which the Honorable High Court has passed the order.
Right.
Lordship. Now, Lordship, if page number, Lordship. Lordship, page number 53 onwards, Lordship.
Yes. Yes.
Lordship, and if I take Lordship attentions to page number 72.
No, 53.
Both,
What then 53?
The differences, the Lordship, the calculation differences, Lordship. Page number 72 and 53, both we have to take simultaneously, Lordship.
Yes. Okay.
Lordship, here they are supposed to deposit the calculation which we have taken into 15/11/97, Lordship. They are supposed to pay Lordship, but here.
No, where are you reading from? From page 53.
First, page 53, Lordship.
Okay, which date?
15/11/1997. Then directly we have come to.
Where the date 15/11/97?
1, 2, 3, 4. Page number 53, fourth line. The calculation, fourth line.
Okay. Oh yes. Okay.
Fourth line.
15/11/97. Right.
Then directly we have come to 15/7/98.
Okay. Yes.
Lordship. So there we have not taken into consideration November, December, January, February, March, April, May, June. These 6 months we have not taken into consideration that time. So obviously, subsequently after sending notice, we have taken into consideration later on.
Is that permissible?
Lordship, the Act has not, for under 14B, there is no limitation, Lordship.
No, because these amounts have already been reconciled. Why that time,
Lordship,
these figures, please listen, were available with you when the matter was heard before this court, correct?
Lordship.
Then this was not pointed out at that point of time that the 6 months has escaped. Is it open for the adjudication? You heard of the talking of double jeopardy, correct?
Lordship.
Can they be tried again for something which they've already been adjudicated?
Lordship.
And penalty be imposed?
Lordship, the months which were.
The thing is that, see, one thing which just expressed the mind of the court,
Yes.
you forget about the amounts that you already have been education. Irrespective of this court will not look into that. If the period which has come in adjudication and an order has been passed by this court saying that, okay, the penalty in 7Q and 14B might be 6-7 lakhs, whatever, you pay a fixed amount of 25% thereof, they've paid that. So fine, that ends there. Now, what is your case after 2001? And why have you clubbed together these periods early of 97 till 2007? Now, you only have to satisfy the court on that. And if you can satisfy the court that, yes, the calculation assessment or whatever from 21 to 2007 has been done on these grounds of delayed payment, which they have failed to regarding the failure to pay on time, for which for damages and interest is payable, then fine, the court will consider that. But if you cannot draw again to say that why this to justify this like 70 you said 72 to justify to add these amounts which are already adjudicated, to carry them forward and to add them to the interest and damages which are present notice, that will not be permissible. Because even this will amount to the escape amount, correct?
This is not an escaped amount.
6 months you have not detected that.
This is escaped
I'm
amount
not
is
talking about
total.
assessment. It'll be another form escape amount.
But,
You didn't assess, and then this material available with you when the matter was here before the court at the 2008. So how can you justify that?
Lordship, that is not an escaped amount. Lordship.
Forget escape amount. How can you justify bring forward this amount from that time to this to your notice, to include in present notice?
Lordship, during that time they have not those 6 months they have not.
Classes for these fraudulent commissioners how to do assessment and all, or these officers. Do they have classes?
They get
have
training.
classes.
Yes, they get.
How it's done, and suppose an amounts already charged, and these type kind of things shouldn't happen. Also escaping 6 months. I mean, this is a glaring error. If you can see, even a layman can see that. It jumps from 1511 to 15298. So they don't take classes. Who's the Provident Fund Commissioner now?
Now Kamlal Belnathiam.
We'll call him. Let him explain.
Lordship, here
if you can generate this kind of notice and pass that kind of order without without even thinking about this, which has already been adjudicated, what amount of contempt the court order also?
Lordship, we have not done anything. The court has
You're only
passed
trying to
an
get
order.
maximum money. We understand, but they won't be contemptuous also. If
Lordship,
you're going back to reassess, an amount has already been adjudicated.
Lordship, they have not paid that time, Lordship.
It was with you that time. It amounts to a review of the order of the court.
Lordship, if they have not paid, how can we take the assessment, Lordship? Because those 6 months they have not paid.
Now he's a landlord, you're a tenant. Okay.
Lordship.
Now you have a lot of accrued rents against him. Fine.
Lordship.
Now you come before some lok adalat or something, and you say, okay, fine. For these months also I'll pay a rent of 20 rupees each, and the amount is given to you or given to the landlord. The landlord comes after some time and gives a notice to you again for defaulter, saying that I forgot to calculate. The 3 months 60 rupees is due, so you're defaulter for those things. So you kindly pay those rent with interest and damages also, and here's eviction notice. So that is similar. So what will you do then? Will you say that no? Will you say, oh, sorry, yes, you're right. I'm a defaulter because I forgot to pay those rent. It's his fault. He missed out those months. Suppose settle, you've paid the rent, accrued rent. Now he says, no, give me for 3 months. Won't it amount to the same thing? What you're trying to argue is that whatever it is happened to settle, but these amounts was not factored in at that point of time. So maybe 25% of this amount is payable now for this amount that escaped. If you apply this court's order.
Lordship, we have actually.
You have the authority on this, which has already been settled, and then later on you open it after a court's order. I don't want to talk too much, but I'm just giving the scenario. This is what you're trying to. Now, what do you want to show in 72?
Page number 85, Lordship.
No, come to 72 first. He's saying, look at it together, 1572 years.
Lordship, Lordship, you are asking for that what we have taken into consideration.
No, yes. Where you've taken early amounts against consideration? Where is that?
We have in our detail order we have passed.
72. Where 72?
Not 85. Page 85 in our detail order.
Okay, where we said that?
Yes. page 85, second paragraph, Lordship.
Yes.
The contention made by the establishment is being summarized as under. The establishment contention is that during the previous assessment covered by order dated dash and demand dated dash, the employer were assessed for the period this to this, and the damage and the interest under section 14B7Q were determined and levied on the employer. However, the intervention of the Honorable Guwahati High Court judgment and order dated judgment dated this, the damage levied were reduced to 25%, and the same was also paid by the employer. In the present demand notice dated 15/12/2021, the employer has been assessed for the period 1097 to 4/2007. Therefore, there undoubtedly appears to be an overlap in the period covered by the previous demand notice dated this for the period 1998 to 6/2001. That the employer cannot be subject to redetermination for the same assessed period twice, and that too after a lapse of 17 years. The submission made by the employer has been examined with reference to the materials on record, rule, position, and the law laid down in this regard. It has been found that for the wage month of 1097, it has been it can be seen from the challan submitted that belated payment of PF dues pertain to the arrear payment of PF dues by the employer, whose delay in payment was not taken into account for the account in the previous demand notice, and hence there is no overlapping of damage dues.
Yes.
Further, from the contention made by the employer establishment, it is clear that there is a confusion between assessment of PF dues under section 7A and penalty imposed for delayed payment of PF dues as determination of escaped amount under section 7C is only in relation to assessment of PF dues made as under section 7A. As the current enquiry relates to damage only, wherein there has been actual delay in
yes, read this.
payment of
Actually, payment of dues for a present period on inquiry and the amounts of which have not been included in a previous demand notice dated 29/4/2005.
And also,
yes,
since the documentary evidence has been submitted to show cause that payment has been made on time for the contention period, the contention of the establishment is therefore rejected and instant. They have not showed anything, Lordship. That is why.
Yes, they have not shown anything because you do not need to show anything. They need to show only your own notice only. Right?
They are after, Lordship, page number 86.
Yes.
It is a statutory obligation on the part of the employer to remit the provident fund dues and other charges within 15 days from the date of close of
Please read this one. This is just
page number.
It's just rattling. Repeating whatever the Act says. Yes.
But the employer has failed to remit the dues of the said period within the stipulated time. The employer provident fund has to comply with the statutory obligation and has to give.
Okay, come to the current period, DC after 2001, which was not covered by the judgment. That we can look at that. Otherwise, what you do is you reassess the entire thing. You bifurcate or you segregate the periods. You cannot touch the period that is up to the period adjudication by this court, otherwise it will be held in contempt, because that's already water under the bridge. And if you are to go forward, you go forward only for the remaining period. That's all, because this is arbitrary action. And appeal also will not serve its purpose. Or you bring authorities. Again, you bring authority to show that's permissible. I'll give you no opportunity, but that's the tentative order that you're going to get. Yes. 1 week. You bring authorities to show that's permissible, even if an amount has been adjudicated, and because then your bond counsel will be in contempt. How did he reopen something which is closed? That means he's sitting in appeal over the order of this court. Correct?
Lordship, the
He's saying that there has been sitting appeal. He's reassessing the order, saying that, oh, sorry, this amount has escaped, so it is not so. Then we will levy it again. So that is what's happened actually. So that that even the court was wrong, and not appreciating that. But then that's not the court's fault or the fault of petitioner. That was your fault. That 6 months was not factored in, right? You get authorities. Yes.
Lordship will conclude this. It'll come up after 1 week.
1 week, let us bring authorities to show that it's permissible. We'll give you ample opportunity because maybe we might call the commissioner to visit the court. Yes. Yes. We thought we'd finish off the other matter today. Yeah.
Me please, Your Lordship.
Yes.
Lordship, may kindly recall this is a similar matter inasmuch as demand has been raised under 14Q, demand for damages, and a demand for interest under 14B, and a demand for
7Q.
7Q.
It's still confusing the section.
Slightly confusing. But unlike the previous matter, my lord, I am on a completely different footing. I am not on the merits, my lord, merits of the demand. On the last occasion, my lord, I had submitted a compilation of judgments. If Lordship kindly allows me to hand over this index that I took the liberty of preparing.
Compilation?
A compilation of judgments that I was relying on, my lord.
This one?
Yes, my lord, yes. So, and just for Lordship's convenience, there is a index that I've prepared in respect of that compilation.
Yes.
Now, my lord, first I draw my lord's attention to the judgment at serial number 4. This is a Supreme Court judgment from 1998, Hindustan Times, my lord. Now
this the compilation?
It is there in the compilation. Now, I will not open the compilation. I'll just take a minute, my lord.
Yeah.
This judgment, my lord, standard judgment relied on by the department in every such matter to the effect that under section 14B,
there's no limitation.
There is no, the Limitation Act will not apply. But, my lord, even if the Honorable Supreme Court has said that the Limitation Act will not apply, what is the implication of that, my lord? We'll have to kindly appreciate the implication. The implication is that if the cause of action arises today, inasmuch as I'm supposed to make a payment today, but I fail to make the payment under the Act, then within 3 years, normally, within 3 years, they are supposed to take action against me under 14B. But because Limitation Act does not apply, that 3-year period is immaterial. So they can take action anytime beyond the 3-year period also. But here the simple question, which I believe Lordship had also appreciated on the last occasion, how much beyond the 3 years can they go? In our case, my lord, they are going as far back as 25 years.
Yes.
So the first point that I was placing for Lordship's consideration was the reasonableness of the demand that is being raised after so many years, my lord. So the first judgment, if Lordship sees in the index.
Yes, one second.
And all these judgments, my lord, have all appreciated that under 14B Limitation Act does not apply. But in spite of that, they have stated that there has to be a reasonableness in the demand. The first judgment, my lord, says very simply that power under 14B has to be exercised within reasonable period. Similarly, my lord, the serial number 2 judgment, my lord, in that case, my lord, there was a delay of 4.5 years. Even that was found to be unreasonable, my lord.
Hindustan Times.
No, this is serial number 2, my lord. Number 4 is Hindustan Times, the standard leading judgment.
This is a Madras judgment.
Yes, my lord. The others are High Court judgments.
Where's the Supreme Court judgment?
I'll just come to that, my lord. Number 4 itself,
You've given a compilation to her also?
I've given last occasion itself. Number 4, that same Hindustan Times judgment, in a certain paragraph, they are saying Limitation Act does not apply. Department always highlights that paragraph, but in paras 25, 26, and 29, they are also saying the same judgment, the same bench is saying that in spite of the fact that Limitation Act does not apply, the establishment is in a position to set up a defense against 14B demand by showing that, number one, this demand raised after so many years will cause irretrievable prejudice. The demand being raised
Where are you reading from?
This is para 25, 26, 29 of Hindustan Times. It's at page 12 of Lordship's of the compilation, my lord. Should I open the
Para?
compilation? Para 25, 26, and 29.
Let me just mark it.
Page 12, my lord.
Detrimental to the SSC, you mean?
Yes, my lord. If I can read para 25, my lord.
Yes.
Gujarat High Court in so-and-so versus so-and-so laid down a principle that prejudice on account of delay could arise if it was proved that it was irretrievable. There it was observed that for purposes of Section 14B, there is no period of limitation prescribed, and that for any negligence on the part of the department in taking proceedings, the employees who are the third parties cannot suffer. It was further observed, the only question that would really survive is the one whether on the facts and circumstances of a given case, the show cause notice issued after lapse of time can be said to be issued beyond reasonable time. The test whether lapse of time is reasonable or not will depend upon the further fact whether the employer in the meantime has changed his position to his detriment and is likely to be irretrievably prejudiced by the belated issuance of such a show cause notice. In this case, Lordship may recall, I had changed my position. From CDA pay scale, I had shifted to IDA pay scale, and it's part of my petition also. So that change made at that time, many years back, is now proving to be detrimental for me on account of the belated demand, 25 years late demand that is being raised on me, my lord. Para 26, my lord. A different aspect of prejudice was referred to in so-and-so versus so-and-so by a learned single judge of the Bombay High Court. It was stated that in some cases, there could be serious prejudice on account of abnormal delay in taking proceedings under Section 14B, either because the records or accounts of the defaulter are lost. My records are lost, my lord. In Lordship, may kindly recall, I was supposed to get records from SBI.
Yes, you've seen that. They could not furnish them.
Till today, I have not got those records, my lord.
Yeah.
Are lost or on account of the personnel concerned acquainted with the facts of a bygone period no longer being available. My employees have retired, my lord, people concerned, for unearthing the facts. But such pleas must be raised before the department and strictly proved. In such case, such facts are proved. It is possible in some cases that there is irretrievable prejudice. And para 29, my lord. Para 29 is slightly long. If I can draw Lordship's attention to the next page, line C, my lord. However, somewhere in the middle, my lord.
Yes, you've got it.
However, the employer can claim prejudice if there is proof that between the period of default and the date of initiation of action under Section 14B, he has changed his position to his detriment to such an extent that if the recovery is made after a large number of years, the prejudice to him is of irretrievable nature. He might also claim prejudice upon proof of loss of all the relevant records, and it repeats the earlier proposition, my lord. So, my lord, the first point being that Limitation Act does not apply very well, my lord. There's no fighting that. But that does not give carte blanche open license to the department to raise the claim as and when at its own sweet will, my lord. My claim is being raised after 25 years. Nothing stops the department, if that claim is allowed, my lord. Nothing stops the department tomorrow raising a claim after 50 years, my lord. That was my first point, that your demand has to be, my lord.
Mens rea, next point.
My second point is mens rea, my lord. If I can take, my lord, to serial number 6 on the index. It's a Supreme Court judgment from 2017. Makes it very clear, my lord. Serial number 6 on the index, my lord. In the index,
Yes,
just for convenience, my lord.
Page 20.
Page 20. I'll read page 20, my lord. Page 20, para 2 and 3. I'll read. High Court has taken a view that in the absence of a finding regarding mens rea actis reus on the part of the employer, action under Section 14B of the so-and-so Act cannot be sustained. Para 3. The issue is now wholly covered against the appellants in the decision rendered by this court in so-and-so versus so-and-so, wherein it has been held in para 11 that the presence or absence of mens rea and or actus reus would be a determinative factor in imposing damages under Section 14B, as also the quantum thereof, since it is not inflexible that 100% of the areas have to be imposed in all the cases. Alternatively stated, if damages have been imposed under Section 14B, it will be only logical that mens rea and or actus reus was prevailing at the relevant time. So a finding, this judgment, my lord, and the previous judgment in the index from Calcutta High Court makes it very clear, my lord, that my mens rea has to be identified, located, and recorded by the department when imposing damages under 14B, my lord, which exercise, my lord, was not undertaken in the impugned orders. Third point, my lord, is based on a full bench judgment of the Honorable Delhi High Court, that is at serial number.
High Court, there is an appeal, lordship. Then it has been reverted back to again to Delhi High Court, though it is not.
I'll address that. I'll address that also. Serial number 8, full bench judgment to the effect that damages under 14B also includes interest. In other words, if you impose damages under 14B, you cannot invoke 7Q to also impose interest on those damages. This was a full court judgment. On the last occasion, I had made a very bold statement that there was no appeal. That was based on my search of SCC. SCC, for some reason, does not, but it still kept on.
Okay, you disregard it. We won't consider it.
I have to place it that there is, from the Supreme Court website, it appears that there is an appeal against that judgment.
It's not that important.
Which is very surprising because Allahabad High Court, Madhya Pradesh High Court.
Because this is a point which has even when you submitted last time, I was a bit.
Yes, ma'am. So that's why I went back and
whether 14B.
I went back and checked the Supreme Court website. So the appeal is there, which is very surprising because MP High Court, Allahabad High Court, till last year, they're still referring to the full bench judgment. So in any event, if Lordship is of the view that this is not a very...
yes.
My last point, my last point. I anticipate, and it had happened on the last occasion, that the point that appeal is there, appeal provision is there, the alternate remedy is there. Whirlpool is there, my lord. Whirlpool Corporation, serial number 9. Very simple, my lord. If there is a jurisdictional error in the order, or if there is a violation of natural justice, then writ jurisdiction is still available in spite of an appeal provision being there.
In Harapan's law, there are many cases.
Absolutely, my lord. Now, in our matter, my lord, 25 years old period is beyond jurisdiction. You cannot reopen a 25-year-old claim, number one. And number two, at the time of passing the order, the two impugned orders, I was not heard. That becomes clear from the order itself. If I can refresh Lordship's memory, the last page, my lord, of the writ petition. I'm sorry, not last page, 61, my lord.
Yes. Dujan Kumar.
Yes, my lord. She so-and-so, however, sought some more time and stated that the detailed and comprehensive explanation of the queries of EPFO Shillong will be submitted along with the relevant documents on the next date of hearing. The submissions of Shri Dujan Kumar, Secretary, is taken on record, and the next date of hearing was fixed on so-and-so at 11 a.m. Shri so-and-so Secretary attended the proceedings on so-and-so, and he prayed for more time to find the records required by EPF office as stated in the previous hearing date at so-and-so. The request is granted. The next date of hearing is fixed on so-and-so. On 25th 5th 2022, Shri Dujan Kumar, Secretary of the establishment, attended the proceeding and submitted a letter reference number so-and-so dated 25th 5 2022, and case was adjourned to so-and-so. On so-and-so, it goes on. Now, this 25th May 2022 is my show cause or my representation or my answer, which is at page 48, my lord. Lordship may kindly recall, Lordship was kind enough to allow me to read the entire show cause or the representation which I had filed, which contained my entire defense. Now, department's response to my defense is, you have submitted your defense. Full stop. What happened to my defense? Have you even read my defense?
Where is that? You said you submitted defense?
That line I had just read, my lord, in the last page of... On 25th...
Submitted letter reference. This
yes,
is the one.
Letter reference so-and-so dated 25th March 2022. That is at page 48, my lord. That is my show cause, my defense. So impugned order clearly shows that I have submitted my defense. But what happened to my defense? Did you even read my defense? What is your response or how do you address my defense? Absolutely nothing. In other words, my lord, I was not heard. My defense was not taken into consideration. So if there is if there's a violation of natural justice, and if the order is beyond jurisdiction, then, my lord, alternative remedy is there, but it does not stop me from coming before this honorable writ court, my lord.
Yes.
On the last occasion, my friend had taken some time to come up with some authorities.
Yes. On 14B?
Lordship, last occasion I took time to check out whether Delhi High Court had appeal, lies appeal or not. Specifically not on authorities, but on Delhi High Court's appeal, Lordship.
So there's an appeal?
There is an appeal.
You've done your task?
Yes, Lordship.
That's it?
And Lordship, further, my learned friend, what he submitted, that submitted a letter, reference number this, and the case was adjourned to 21/10/2022.
Yes.
On this is what we have passed the letter. On 21/10/20, because on very that day, the letter, after submitting the letter, the case got adjourned. Thereafter, we have directed them to, we have also asked them that, okay, your hasn't point-wise clarification, we sought for point-wise clarification, and further we sought for bank details. That yes, you provide us a bank details, and further sought for clarification. Later on, at the end of the paragraph, we have also, on verification of challan submitted by the establishment, it is seen that last part.
Okay.
On verification of the challan submitted by the establishment, it is seen that for the wage month dash 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 and dash, now I go to page 62, the challans were deposited within the grace period of 5 days. For the wage month this, the number of delays were revised and taken as 7 to 10 days respectively, and the damage and interest has been calculated accordingly and duly intimated to the establishment. So after, this is what we have taken into consideration.
After studying the show cause?
After studying the show cause and after taking their challans into consideration.
Let me note down the submission is. Show cause noted and observations made.
Observation made.
Okay.
Then 62 only, that very paragraphs, 62 only, that very paragraphs, last part regarding last third line, last 62, the paragraph, continuing paragraph and last third line regarding the reasons for their inability to provide the documents, Lordship.
Yes.
Be it the number of employees who have opted on a particular month, that is dash for IDA pay pattern, the establishment representative stated, now on enquiry, Lordship, that they have changed the pattern, that we have, that for this month, the employees, they have to opt for the pattern also to change. The establishment representative stated that the arrear payment can be given to the employees only when option is made by the particular employees, and that is the record patterns to a period of 25 years back. They are unable to provide the data substituting that this particular payment of dues relates to arrear payment of the employees. Also for the month of 395, they have stated they couldn't trace out the old records. Lordship, it is the if their pattern is changing, Lordship, the employees are not opting for their change pattern, EPF is not liable for that. It is they have to take the initiative.
So what happens in the event that the records can't be traced? They've shown before you that they've tried to trace the records, they've written to the bank, but the bank says before digitization, and so it's impossible
then
to track the
they
records.
have to rely on our records, what our record speaks. Our records.
You ask for the records.
We have asked for the records.
And so if the submitting to your to your request will is detrimental
Lordship,
to them.
here I remember something like that when our bar got gutted, and those people who have paid their dues, and some people retained the challans, some of us the receipts which we have paid, we got exempted. Okay, fine, we have paid up to this. Otherwise, those who have not paid, they had to repay those from past 1 year, something like that. So the same thing.
Is that true, Ms. Jindal? You want me to pay again? Your membership fee.
No.
Yeah.
Lordship, they have to rely on our records that they have not paid. Since they have...
in this case, it's contra.
If they
It's that
already-
you don't have the record, also you rely
If
on
they
no
already have
records to pay.
If they already have records, they couldn't have passed this order against me based on the fact that I don't have records. If you already have, why are you asking me for records?
No, we verify from our with our records that
You're
some of
compliant with natural justice to allow you to show your records. Anyway, yes.
and further, Lordship, this is an under 14B 7Q is 14B is an appealable order, Lordship, appealable order. So they have an option to file an appeal, Lordship. Further, in Hindustan, there I have actually going into in my affidavit, page 3, I have entirely covered what is our contention, and we have also stated page 11
Of your affidavit.
of my affidavit, page 11.
Yes.
Page 11. It has been held that Limitation Act 1963 has no application to labor court, and in our view, that principle is equally applicable to recovery by the concerned authority under Section 14B. Further, Bombay Gas Company
Which
Limited.
judgment is this? 70 SCR. What's 70 SCR? Observations is Hindustan Times is 1998.
Lordship.
Now, Hindustan Times itself, they refer to 1970 on CR.
They have taken the...
Now you see, they distinguish. They don't. What reasons have been recently so.
Yes, Lordship. It has been held in respect of an application under Section this, the Industrial Dispute Act.
Where's the compilation?
It.
1 second. One second. First contention. Where you quoted this part from? This first, where he quote this para 11 from? Where you
Lordship, I'll just get.
where do you get the first contention? We have appellant in context. Where do you get this from? Which part of the judgment?
Lordship, I'll just find out from the compilation, Lordship.
Unless it's a different Hindustan Time judgment.
My lord, unfortunately, my compilation is not the complete judgment. I've just taken the relevant portions that are.
Oh, that's unfair then. I got one.
Sorry about that.
You should have. Then you should have. Yes, I got one. 98.
1998, 2 SCC, 242.
Oh, that's unfair then, Mr. Jindal.
I apologize, my lord.
You should
Just
have
to
limited
because
to
it's a huge.
You wanted to save
paper, my lord. That's all.
Paper or money and photocopying?
Both.
Yeah, 254 to 55. It goes from. Yes, 42, I mean 10 pages, around 8 pages have not been, that's all. 8 pages we haven't been
Yes,
produced.
because the portion relevant for them is there in their show in the.
Deputy Lordship, I have already.
That's not allowed. It's not done. I mean, in all fairness,
I apologize.
If you give a compilation, it helps the court, so you don't have to take out the book.
True, my lord. True, my lord. Fault is mine, my lord.
Do you have the judgment with you?
Lordship, I'll just get the online judgment through AIR, Lordship. I'll just get the judgment through online. Because I have quoted in my affidavit, so entire judgment I quoted.
You know what is we taught before? This is very true today also, that don't read the excerpts. If you want to understand the judgment, read the whole judgment. You know?
Lordship.
Because there might be sometimes lawyers quote a portion that's only, helpful to them. But sometimes there's another observation that they also might, which dilute the observations made earlier. So those are the things. It's only the point not prevent limitation, but the reasons for them to, because it's correct, because there's how they have, analyzed the situation and come from para 25. I was looking for that part, I couldn't find it here.
I was also looking, Lordship, that I also didn't get.
Interesting.
Lordship, if I'm allowed to place a small submission, I am conceding, my lord, that Limitation Act does not apply.
Of course.
There is no.
But let us see what she has placed. Let's see in the judgment as well. We are not saying that there is called unique finding, but you are just on the ground of reasonableness.
Absolutely. I'm saying Limitation Act does not apply, but however, in spite of that, you have to be reasonable about things.
Do you get it?
Yes.
Islam dah kata nak kuat dulu.
Islam ailis lupa ada semua.
Yang brave tentang mentak Islam dah. No Malaysia.
Pas library ni lah.
Belum dapat apa kamera ber 2 minutes tak waktu kan. Yes, para 18. Are you quoting para 18 to a judgment? Where's the affidavit? Para 22 is where the distinction is made from what's been placed in affidavit. You quoted from para 34.
Yes, Lordship, para 34.
Yes. You left out 18 to 23. So they say even though no limitation, reasonable time, but in just para 30.
Paras 25, 26, and 29 is what I'm relying on.
So we have to discern whether it's irretrievable and irreparable loss will cause to you. Yes. Yes. Continue.
Yes. So, Lordship, in Hindustan Times, what like it's in our some of the judgments, portion of the judgments is in our favor.
In your favor with regard to non-applicability of limitation.
Lordship.
But every case, look, in this case, it said there was the Hindustan Times could not show that irreparable damage be done to it, and so that is why
Yes, Lordship,
they were not given the relief.
Lordship.
But then they have also dwelt on reasonableness also.
Lordship, in this case, it is the Provident Fund. It was in favor of Provident Fund. The case was in favor of
Yes.
Provident Fund, and more so, the case went as an appeal, Lordship. This means it has right from the tribunal. It has gone through the tribunal, Lordship. So my also contention is that if such type of case, since they are aggrieved by under 14B order, they have to go to the tribunal
Yes.
and place their case based on the evidence and
Now you say that now another point. See, what they heard, what they given.
Lordship, their show cause was taken on records. We have passed an order on that. We have given them the chance to produce the challans, whatever they have. we have I have drawn your lordship attention to their contention that the change of positions, that if they have changed, the employees, they have not changed their position. We have covered entire thing in our order, lordship. It's not that we have not given.
Exactly how many years? That's how many years? Assessment year and demand.
If Lordship kindly looks at Annexure 1, page 22. Just below the first column, my lord. Now, the scrutiny of the records maintained by this office for the remittance made by you during the period from 1/4/1996 to 31/3/2014. And notice is dated
21.
21, my lord.
14 is just 7 years.
7 years.
Yes.
That is the earliest period. The most ancient period is about 22 years. 25, about 23 to 25 years.
Anything else?
Nothing, lordship. The only thing, my only prayer is that it is a fit case to go for appeal, and the appeal lies in this case. So, lordship.
Yes. We'll pass orders then.
Lordship, 2 points, my lord. 2 quick responses, my lord. Number one, my lord, my friend had made the first submission that show cause was taken on board and noted. And considered, my lord. In support of that, my lord, has my friend has drawn lordship's attention to page 62, where challans have been, etc. Factual things. My lord, that does not show that my show cause was looked at, because if lordship looks at my show cause at page 48, not a single statement is there on challans, nothing on merits. In my show cause, I was only on the legal aspects, that a 25-year-old claim cannot be raised without jurisdiction it is, etc., etc. Whatever I have stated before this honorable court today, nothing on facts, no challan was mentioned, nothing on the merits, my lord. So my friend, for my friend to say that the merits reflected in the impugn order shows that my show cause was taken on board. My show cause has no connection with what is contained in the impugn order. Number one, my lord. Number two,
Yes.
again, just very quickly for the final time on the Hindustan Times judgment.
Yes.
Just reiterating myself, my lord. Hindustan Times says Limitation Act does not apply. The obvious repercussion, the consequence of that is, I cannot hope to convince this honorable court that because the demand is made after 3 years of the demand of the accrual of cause of action, the demand is barred, should be considered as barred. I am not even attempting to say that, my lord. So the only implication of Hindustan Times, the portion she is relying on, is to the effect that Limitation Act does not apply. I am also in agreement with that. Limitation Act does not apply. I am on a slightly more different footing, that your demand after limitation has to be within a reasonable period. 25 years later, by no measurement can be considered to be reasonable, my lord.
So, are any records available for the period 2014-13? No records.
Lordship, whatever was available, we have submitted. Those challans which my friend had referred to.
For which years?
Different years, my lord. Different years. If Lordship looks at 62, different years, my lord. 2008, 2010, 1999. They are for different years. Page 62, my lord. The portion that my friend had read. 61, last portion, plus 62, my lord. Some various challans, etc. are referred.
But he says that, see, on very challans submitted so which is month, the challans are deposited within the grace period of 5 days. Is not in contention.
Yes, my lord.
For wages month 2025, the amount of delays, they was revised and taken as 7-10 days, and damage or interest had been calculated accordingly and intimated establishment. For 99, the contestation was rejected. That means, you see, the thing is that they have broken up their assessment. I mean, they've broken up their, consideration into years. Some challans which you produce is, okay, fine, within 5 days, okay. Then the others, delays been revised to 7 to 10 days, and they have calculated damage and interest, and for the wage month 799 is rejected on scrutiny. The chance of found this variation amount so and so and so chance of for no proper so and so and so with regard to the variation for 2008. So can't we say there has been a subjective kind and objective kind of assessment of the documents that you given? Okay, leave aside the 96 to
Yes,
maybe 2000 or something.
Yes, ma'am.
2001, because from 2001 you've given your
We've given, my lord, we've given, admittedly, evidently, we've given some documents, some relevant documents. Some we have not given, including bank statements, etc. Now, my lord, I'm not on the merits, my lord. What has come from my lord is possibly true, that there has been some sort of calculations and
there has been an objective kind of assessment, yes.
Yes, my lord. But my point is different, my lord, and lordship has seen it. My point is that such an old claim, for such an ancient period, you do not have the jurisdiction. That is my point. I'm not on the merits, my lord. And lastly, my lord, repeatedly my friend has stated that I have to go for appeal. Lordship, this question is an answered question. If there is jurisdictional error, or if I have not been heard, which I have clearly not been heard, I can still come before this honourable court. Hindustan Times might have come through an appeal process. That is on the merits of that case.
Yes.
My case is different, my lord.
Yes.
Obliged.
Right. Reserved judgment.
Obliged.
Pardon, Lordship?
Hearing concluded, judgment reserved.
Lordship.
Item number 4.
Can you just give me 5 minutes? Let's come back, please. Yes.
Your Lordship, before my friend replies, yesterday, before the commencement of the hearing, the issue was that whether this court is bound by Commercian and so also Solongpiao. Your Lordship, after going through the Commercian thoroughly, Commercian did not address the most important issue, vis-a-vis the notification. The notification issued by the government applying the CRPC to the courts in Meghalaya.
That September 22.
Yes, September 22, which has again, Your Lordship, I had given the copy.
Nobody has mentioned it. That now CRP is applicable, so you can't say
Now,
that the
yes.
you can't say the court's district sessions judge they cannot unconstitutional
No,
sense that they
even-
were under powers of under 37 rules. Yes.
No, but then the powers that the district council court shall continue to derive powers under paragraph 4 and
4
5
and 5, yes.
of the 6th schedule. This aspect has not been addressed, which means that in Commercian case, the division bench was silent, sub silento. But the maximum of sub silento will come into play. It did not address this issue. That even before the applicability of CRPC, the Lordship is very well aware, other districts where the district council courts have not been empowered, they were trying cases. They were trying cases. Now, the issue here, my lord, is that whether, in view of this notification 22, the powers of the district council courts have been taken away. That issue has not been addressed.
No, they can't be taken away.
Yes.
It's a constitutional provision.
It's a constitutional provision. Exactly. Exactly, my lord. As held in Solongpiao case. Solongpiao case says that 4 and 5 has to be read together. My lord, if you see the...
So it's not read, they say reading it together.
Reading it, my lord, in the last paragraph of Solongpiao case, 10.6. Now, in the instant case, it is an admitted position that the victim and the accused respondent both belong to the Khashi Cheru tribes. Thus, given that there is a specific notification dated 7/2/2017 that confers the district council courts with powers under the CRPC to try certain criminal offences, we find that such conferral should be given effect. In fact, upon a combined reading of paragraph 4 and 5 of the 6th schedule, such district councils has the exclusive jurisdiction to entertain such a case. Now, the Commercian case, the division bench has said, in view of the notification of 22, the district judge has the power to try these cases. Stop there. Without examining the fact that the district council also, the powers have been saved by 4 and 5. So my contention is that this court will not be bound by the decision of Commercian because it was silent on this issue.
That is a bit difficult anyway.
Yes.
But it's not the issue that's arisen, but I will not voice it. That just came to my mind yesterday when I was hearing you all. Anyway, but I'll not, that is, we might bring up another issue which is, further complicate the matter. It's just, anyway.
Yes.
Okay. But then, now, Advocate General said that Melvin Solongpiao was on two different circumstances. That is what he said yesterday.
Yes.
That you have to say, like, where Melvin Solongpiao will apply
No,
evenly. The whatever has been held will apply, throughout. It's like in rem. You understand? Yes.
Yes. But then, if that be the case, now what is the intention of the governor? Even after the Solongpiao case, conferral of powers has been continuing with the district council.
Yes.
Both the notification I brought.
But then again, if you read the sixth schedule properly, is that yes, even it envisages a situation where 5.1. I mean paragraph 5.1.
Exactly, that's the point where this court has to come in, because
That
both
is
courts, because as per Solongpiao and Commercian, both the district councils as well as the district judge would have powers. Now, who would decide that? Which forum would decide that? Would it be the accused person or would it be the complainant? Now, that's the difficulty, man.
So what are we to do then? You want to refer to the larger bench? Otherwise, see, whatever it
because
is,
I'm saying
whatever it is,
yes.
Mr. Dingno, is that judicial discipline means that, you know, yes. We examining it, whatever, might be, it might be incorrect.
It might be correct. No,
it's not that this court's in division bench and dissent from the orders. Like, it's not.
No, I'm not asking this court to dissent. What I'm saying
You're
is
asking
that
this court to supplement.
the division bench has.
But one thing what you're asking this court to do is supplement the findings of the division bench to go into an area which is subsilent. It is supplement. It will amount to it will amount to asking to supplement the judgment to make clearer. But in fact, it will supplant it. So I mean, I don't see. I cannot. This court cannot give a finding that will supplant the findings which arrive at commercial. No, you have to understand that we are in a very, you know, the road is very narrow.
I understand that, my lord. But then Solang Peo case is there.
But it's very,
of course, my learned friends, this is more of an academic, because I'm standing for the district council.
Yes.
But Solang Peo case is there.
I understand. So then it was disregarded, and African Journal said that it was not pleased by Mr. Changreso because he cleverly understood that it would have no relevance in the discourse with regard to Komrichan. That's what he said yesterday.
Then the AG should have placed it. He would have helped his case. But this is a judgment of the Supreme Court.
It was not at all applicable, Milord. It was. I have shown it is not. Ratio is not at all applicable. Ratio was not at all applicable.
Otherwise, you see, because if you want, the only thing, see, hands are tied. We can only say that.
Understand.
We can only say that fine. You know, in the petition given in 5-1, we have to accept it, and you know that the case not be held up. And in some cases, evidence has been led. That's why this court is interested in finishing off the matter. Again, to the.
What I've been made to understand, even cases where the punishment is below 5 years, they have stopped being transferred to district council. There's no transfer of cases be taking place.
Can you give the list of cases? From which court?
We will supply. I think
there is not all, in all these cases. That can be taken on the administrative side, my lord, but judicial side, my lord, matter on the administrative side, it can be taken care of, my lord.
Then if that's the case, my lord, I think there's a fit case to refer it to the larger bench. As your lordship has voiced out, it would be a very difficult proposition to come to any definite conclusion. Subject to what my friends say.
As a bond was judicial discipline, then you have to go. But then commission has been appealed against.
Yes, that's what I've been.
What happened is trials that happened.
No, my lord, my knowledge, no appeal, nothing, as on today also. And the conviction has been recorded, my lord, and against the conviction, the High Court has also upheld that matter.
Yes.
Because the whole argument, entire argument of my learned,
you're not very,
entire argument of my learned friend.
Yes.
Network issue is there.
I think with the Archival Journal, you'll be available next week. Will you be in Shillong next week? Look as if he's in pain. Will you be in Shillong next week?
Monday, your lordship, yes, I will be there to have also of our chief justice. But your lordship, whatever is convenient to your lordship.
Tuesday, you be here on Tuesday. That is the
Tuesday.
6th. Another matter is fixed for final disposal.
7th,
you be here. 7th.
Seventh, we have some probably itinerary or program which is going to take place. Your lordship have next week, I think after next.
Not 8. They're going to Bhutan.
8, 9 will be probably. Yes, your lordship have after Sunday, next Sunday.
Yes, okay, we'll have it on 13th. We'll have it on 19th. You waited for so long. 19th. 19th. You'll be here. 19th August.
Okay.
19th August.
Right.
19, yes. As certain reservations have been raised by
Obliged,
the
One name.
counsel for the parties, and as the physical presence of Advocate General is necessary, list this matter 19th, the fixed item. We'll try to finish it off.
Yes. I have deeply appreciate.
I was hopeful of finishing it today and over the weekend.
Yes,
No, I think that is the only point which has to be decided whether this.
There's not a point has arisen, in my mind, which I don't want to voice it. Then if if force of common sense judgment, if I voice that point, it might, I might be wrong, but I mean it has, it's just in my mind. It's a proposition. It's not a proposition. It eventually might happen.
I see the government has created all this. If they stop conferring powers, matter ends there.
Exactly. Because we're having a serious problem, just to share with the bar, is that we upload to CIS and we are bound in the e-courts now. It's very strict with regard to next date should be given and orders are uploaded for the benefit of the litigants and the lawyers.
Yes.
Now what has happened is that with this thing is that now cases are being flagged. They come out red in the national grid with criminal appeals have been pending. So we have so much.
I think I know what's in your lordship's mind.
90. And so when we had gone for meeting last time, it's very embarrassing that they say there's some cases in your subordinate courts. They don't know difference.
Yes.
And it was flashed up on the screen, that these are the cases that have been pending since 89, 90. So it's very embarrassing. And when and all those cases are from district council. That's the thing. So if it's for the benefit of the litigants, we have to think, of course, legally is something else, but then we have to put a system that is,
And we have got, and all these regular session courts are manned by the people from Meghalaya to the extent of 85%.
Even that time we used to talk about it, that
and we have got
it doesn't matter. It is the same thing. All people they can go to any court. It should be open.
Yes, my lord. And we have.
But we can't have that pendency, that if we have slow pendency and we have 1,000-something cases pending out there, that, and the cases are very old. So we have 30 years plus cases also in civil matters.
Yes,
so that is very embarrassing.
This has been an issue for quite some time.
It's very embarrassing for us, and some orders have not been passed, which have been heard in 2018, heard in 17, which have been reserved for judgments. How are we to answer? And in this age of, everything's accessible in every portal and technology, and you have these meetings, and if the Chief Justice of India is attending, it's flashed on the screen, it's very embarrassing.
Governor could have keep in mind that situation before invoking that section 5, the paragraph 5 plan also.
Confirm, no, whatever it is.
List item number 9. Item number 9.
Yes.
Good.
My lord,
My lord,
state is
this
supposed to
matter
file the
came up on
report.
29th of May. Lordship, my lord, this is the school, Mauropat school, my lord. So on 29th of May, Lordship has directed, giving an opportunity for the petitioner to submit his written statement and a fresh report to be filed. I've already submitted to the court master, my lord, the report which I received from the department, my lord.
Yes.
So, my lord, may I have this matter on?
Such a huge inquiry report.
My lord, because it appears that the petitioner has given lots of documents.
That he's satisfied he's been heard
My
now.
lord, it may be noted that the petitioner did not come forward to the office. His daughter has come and submitted. And we have to give two reminders, my lord. Two reminders were given.
He was not keeping well. And he will not take the plea that the opportunity was not given to him. He has given.
Yes,
And my lord,
inquiry
two
report
notices
is
were
directed,
given.
which is report as directed by order date 29/5/2024 has been submitted by the learned GA MSR Colney. The same is taken on record. We'll open the next day. Yes. Listed when?
Next week after subject to lordship convenience.
Convenience of the court, my lord. We have already done.
Yes.
My lord, lordship's convenience, my lord.
It's got after 1 week.
Yes. Obliged.
Item 21.
Ready the matter today?
I
Actually, my senior is busy, but now
He's gone to sleep.
I have no idea. He was there just now, but
Okay. When? Tomorrow? Next week?
Next week.
We'll do it. Yes.
Right.
His unavailability of consider doesn't matter next week, yes. We've waited long enough.
27.
I may persist, Your Lordship. Lordship, if this matter can be taken up tomorrow, Your Lordship.
Why?
Lordship, I'll have some more instruction, Your Lordship.
Some more instructions?
Some more instruction, Your Lordship. By tomorrow, I'll have.
Fellows retiring in October.
October.
31st October.
Mr. Elder AAG, please have allowed listed on Monday. They're able to obtain full instructions.
Lordship, yes. Apply, Your Lordship.
That's why you see, otherwise the whole thing will go. All those other people,
Lordship,
if you...
Lordship, I'll please Your Lordship, because, Lordship, we were informed, Your Lordship, that there is a letter addressed by the lawyer asking the government not to hold the DPC, Your Lordship. Believing that in good faith, Your Lordship, that there was a stay order, Your Lordship, no DPC was held, Your Lordship.
When?
And as a result, Your Lordship, and
It's been deprived.
And as a result, people have been deprived, Your Lordship. I'll please.
Is that correct? By you, Mr. Datta?
Lordship, I'll please that, Your Lordship.
I have no knowledge about that.
Lordship, I'll please
It's
it.
not the first time. Like yesterday, also some other case you
I'll
filed
please that,
where
Your Lordship.
petitioners already come before the court.
Lordship,
At
I'll
least when
please
you
that,
meet
Your
your client, you tell them have they come before. I mean, otherwise your client will have that other case will have serious problems.
Apply, Your Lordship.
Yes. This case, no? Completing who?
Lordship, we have filed an application that is misapplication.
3 to 10.
Yes, 3 to 10, to implead them in their official capacity.
Why give the names then?
Names will be removed, Your Lordship, but they have to be identified. Who are they?
No,
because the designation is
if you're
same.
against the decision of the chair, it's not the
Yeah.
person.
But designation is the same.
This won't work, Mr. Datta.
Yeah.
You amended, you
Director
corrected.
NIPCO,
You just
Director
put
NIPCO,
by-
Director
Yes,
NIPCO,
I
all
did that.
directors.
Lordship, if I can, on the last occasion also I pointed out the entire matter can be disposed, my lord. For the last 10 months, petitioner has been going around on this impleadment issue because he's raised a money claim, a claim for 4 crores. Now he wants the money from NEPCO, the company, or from Shri so-and-so, Shri so-and-so. He wants it from the company. So company is already a party. So why are we wasting time on this impleadment of directors issue, my lord? My humble request,
Lordship, my humble request is to dispose of this petition, mispetition.
This has to be dismissed, my lord.
Misapplication. Because
Let's see your prayer.
Page
Let's see your prayer. Mr.
Page
Datta.
18, my lord. Writ petition.
Yes.
Page 18, my lord. First prayer. Prayer A.
18.
Page 18. In the
You have not alleged any malafide against them?
Absolutely no.
Then?
Nothing.
And what the original parties are? You made them all by name.
By name. Same.
so that is why now we want to implead them in their official capacity, my lord, not by name. I have given the name just for identification that they are all directors and no designation is clear here. So all directors.
Why directors? Why don't we directors?
There are so many directors.
The chairman and or CMD, whatever is called, he represents the board.
They were involved in this case, Your Lordship.
How was
Why,
the-
why do you want him to Datta? What is the reason?
See my petition,
On the last occasion, my senior had made a submission. They need to be impleaded, otherwise they will go scot-free. Now, what is the meaning of that, my lord?
para 12 of my
Scot-free from
petition,
what, my
Lordship.
Para 12.
No, not para 12, page 12 and para 15.
Yes.
The petitioner state that the directors of the respondent number 2, being respondent number 3 to 10, have arbitrarily withheld the dues of the petitioner in spite of issuing completion certificates after being satisfied with the work of other petitioner number 1. Then 16, para 16, the petitioner state that the respondent number 2 to 10 had no reason whatsoever to withhold the payment of the petitioners. Then page 14, Your Lordship. And
what is the amount due? These are what? These are security deposits?
No, according to them, this is pending payment for work that they had done for me.
But then there's no arbitration clause.
There isn't. I'm not very sure about that.
When was the contract concluded?
I'll see the completion certificate, Your Lordship.
Yes.
76.
Page 9 of my show cause, my lord, of my affidavit.
76, Your Lordship. This is to certify that MS.
Can I see your affidavit?
Page 9, my lord. There were 2 projects. Page 9 is for one project.
Page 9?
Page 9 of the affidavit. There were 2 works, 2 projects. Page 9 is for one project. Known demand certificate by contractor. This is dated 23rd March 2020. Page 9, my lord. 23rd March 2020.
How was this writ maintainable in the contractual
Your
matter?
Lordship, the work was completed on 31st December 2017.
See, Mr. Datta, I understand that when you come to court, the writ court for seeking recovery of any money, and if you bring forward disputed facts or the bills are not certified, you won't get any relief. Only that if the dues are there as certified, the dues are that you have to get those outstanding dues.
Yes, my lord.
Then maybe a mandamus can issue to expedite, to examine your, you pay to take a security deposit or a performance guarantee, something like that.
Yes.
That is a fixed amount, right? But then if you're coming for realization of your contractor's bills, and in the absence of an arbitration clause, you have to go to commercial code.
In that case, necessary order may be passed to Your Lordship. Yeah.
I like that. Yes.
Yeah.
Because you have to show that, anyway.
So I pray necessary order may be passed to Your Lordship in that case.
There's no arbitration clause. Why? You see, NIPCO always inserts an arbitration
True, my
clause.
lord. I tried inquiring about this, but unfortunately, there was no clear answer, because if there is a arbitration clause, the law is very clear, you have to invoke that first.
In the bid paper, it is there, my lordship.
The bid document is there.
Bid document is there.
But
At the
in
moment,
the
I don't have with me,
agreement
but
it's
it is
not there.
there. It is there.
In the contract agreement is not
Yes,
there.
arbitration
It's there.
clause is there. Yeah.
In the contract agreement.
Then it's even more clear, my lord, that he has to invoke arbitration, my lord.
Where's that?
I have not brought it, Your Lordship. I'm so sorry. I apologize for that. It's very
Don't
bulky.
apologize.
Yeah.
You list it tomorrow. You just get the information whether it's arbitration clause or not. Though this matters come up today for implement of certain parties' interpretation, on examining the matter, it appears that it is a contractual dispute. Stop. Next, Mr. D.K. Datta submits that perhaps there might be an arbitration clause, which he seeks 1 day's time to ascertain, and to price the court. So also Mr. S. Jindal. List tomorrow.
Obliged.
Obliged.
Second call, item number 2.
Hello. Okay. Yes. Yes.
My lord, my humble apologies, my lord, for not being able.
No, we have the courts made.
My lord, here one difficulty, my lord, is that, my lord, I have received the affidavit, but again they committed a mistake, my lord.
You've given copy to him?
No, I have not given a copy, my lord. My lord, here
Mr. P.B. Bhattacharya submits that
my lord, here it's
the non why on one side.
Yes, my lord. So again,
Violence, so what? Why it is not allowed now?
My lord, it's not allowed. My lord, if
Mr. Q submit that as there is some defect in the formatting of the affidavits received, he please be allowed 2 weeks further time to file the same. Yes, this is thereafter.
Supplementary 1, item number 1.
Yeah. This matter is listed today and mention being made by Mr. R. Debnath, accounts CGC for support number 1 and 2. He submitted that the non-appearance yesterday, non-appearance 31/7/2024 was caused due to illness. Stop. Accordingly, the orders dated 31/7/2024 stands withdrawn. This is the case after.
Same date.
Yes, this is as fixed earlier on 9/8/2024.